Before we even hear the case number, let me set the stage for you, because this courtroom appearance is not about a single mistake. This is about a slow-motion collapse of probation compliance that spans months, medical claims, substance abuse struggles, and ultimately, a judge who has clearly reached the end of his patience. We're talking about Sarah Rose Watts, a defendant facing more than 20 probation violations tied to missed testing, failed treatment programs, and repeated failures to use a SoberLink alcohol monitoring device. On paper, this looks bad. In real life, it's worse, because this court has already given her chances. The real question here isn't whether she violated probation. She admits that. The real question is why, and whether those explanations hold up under scrutiny. Medical emergencies, mental health struggles, addiction recovery, financial hardship. All of it collides right here. And as this hearing unfolds, pay close attention to the judge's tone, the timeline gaps, and the moments where sympathy turns into frustration. Because this case is a masterclass in how probation violations snowball, and how fast a judge can go from understanding to done.
Sarah Rose Watts, 23F239919.
Good morning, Judge. We have the TOP 82378 on behalf of Ms. Watts. Ms. Watts, state your name for the courtroom, Judge.
That's zooming.
Sarah Rose Watts.
All right. Counsel, you got your work cut out for you. Shouldn't have been here. So we've got failure to attend the court work program in October of 23, specifically on October 14. Failure to provide proof of attending and or completing intensive outpatient treatment. And then we've got all kinds of counts here on failure to submit the weekly testing back September 8, 28 of 23, October 2, October 10 of 23, and then failure to submit to a multitude of SoberLink blows beginning September 25th and ending on October 16 of 23. So how was she doing?
Right here is where the gravity of the situation really sinks in. When the court lists out violations like this, failure to attend court work programs, failure to complete treatment, repeated missed alcohol tests, it's not just procedural housekeeping. Each one of these violations independently gives the judge legal authority to revoke probation entirely. And when you hear the judge warn her that she could face up to 93 days in jail, that's not posturing. That's the statutory maximum tied to the underlying offense. What's especially important here is that she's pleading guilty with an explanation. That means the court accepts the violations as fact, but still listens to mitigation. However, mitigation only matters if it explains why compliance was impossible, not just difficult. Medical documentation can help, but timelines matter, proof matters, and consistency matters. As you listen to her say guilty over and over again, ask yourself, at what point does explanation stop being context and start sounding like excuse?
To proceed on this.
So, Your Honor, she wants to plead guilty with an explanation to all the violations. She has some medical issues, and she has a folder full of medical documentation. There's also some medical documentation in the file that she was sending in 2023. She's also had some substance abuse at the time. She's willing to take responsibility for disappearing from court, but she does have very valid.
All right, well, I'll listen to it. She wants to plead guilty to these 20 counts?
Yeah, 20.
There's 20 counts.
Oh, with the SoberLink judge.
Correct.
Right, yeah.
Is that what you want to do, ma'am?
Yes.
If you plead guilty here, your probation could be revoked. You could be incarcerated for up to 93 days with credit for any time served. Do you understand that?
I understand.
Did you sign the advice of rights and read and understand the rights?
Yeah,
This advice of rights, the yellow advice of rights.
yes, I did. Yes.
If you plead guilty, you will be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that?
I do.
All right, as to count one, that you failed to attend the court work program on October 24 of 23, how do you plead?
Guilty.
Count two, that you failed to provide proof of attending and or completing an intensive outpatient treatment program, how do you plead?
Guilty.
Count three, that you failed to submit the weekly testing as ordered on September 28 of 23.
Oh, correct. Oh, guilty.
Count four, that you failed to submit the weekly testing as ordered on October 2nd of 23. How do you plead?
Guilty.
Count five, that you failed to submit the testing as ordered on October 10 of 23. How do you plead?
Guilty.
Okay. Count 6, that you failed to blow into a sober link on September 25 of 23 at 7 p.m. How do you plead?
Guilty.
Count 7, that you failed to blow into a sober link on September 28th at 11 p.m. of 23. How do you plead?
Guilty.
Count 8, that you failed to blow into a sober link on September 29th of 23 at 11 a.m., 3 p.m., 7 p.m., and 11 p.m. How do you plead?
Guilty.
Count 11, that you failed to blow into a sober link on October 3 of 23 at 7 and 11 a.m. How do you plead?
Guilty.
Count 12, that you failed to blow into your sober link October 5 of 23 at 7 and 11 p.m. How do you plead?
Guilty.
Count 13, that you failed to blow into the sober link at all on October 6 of 23. How do you plead?
Guilty.
Count 14, that you failed to blow into a sober link at all on October 7 of 23. How do you plead?
Guilty.
Count 15, that you failed to blow into a sober link on October 8 of 23. How do you plead?
Guilty.
Count 16, that you failed to blow into the sober link all day on October 9 of 23. How do you plead?
Guilty.
Count 17, that you failed to blow into a sober link on October 10 of 23. How do you plead?
Guilty.
18, that you failed to blow into a sober link on October 11 of 23. How do you plead?
Guilty.
19, that you failed to blow into a sober link on October 12 of 23. How do you plead?
Guilty.
20, that you failed to blow into a sober link on October 13 of 23. How do you plead?
Guilty.
Count 21, that you failed to blow into a sober link at all on October 15 of 23. How do you plead?
Guilty.
Count 22, that you failed to blow into a sober link on October 15 of 23 all day. How do you plead?
Guilty.
Count 23, that you failed to blow into a sober link on October 16 of 23 all day. How do you plead?
Guilty.
All right.
Let's pause here, because what we just witnessed is something most defendants never experience in open court. Over 20 separate probation violations, read one by one, with a guilty plea entered on nearly every single count. That repetition isn't accidental. Judges do this deliberately. It forces the defendant and everyone watching to confront the pattern. This isn't one mistest or one bad week. This is weeks of non-compliance stacked on top of each other. And notice how the judge shifts from reading violations to confirming facts directly with her. This is the court locking in the record. Once she answers correct to each question, there's no walking it back later. No appeal argument that she didn't understand. No claim of confusion. This is procedural precision, and it sets the stage for sentencing. So here's the engagement question for you. If you were the judge, would the sheer volume of violations outweigh the explanations before you even hear them?
First of all, did you fail to blow into the sober links between September 25th? Well, first of all, let's say between October 6th and October 16th and 23 all day.
I kind of just dropped doing what I was supposed to do.
I didn't ask you that. Did you fail to blow into the sober link on those days?
Correct.
Did you fail to complete an intensive outpatient treatment program?
Correct.
Did you fail to attend the court work program on October 14 of 23?
Correct.
Did you fail to submit the chemical testing as ordered on September 28, October 2, and October 10 of 23?
Correct.
And did you fail to blow into the sober link at various times between September 25, September 28, September 29, September 30, October 2, October 3, and October 5?
Correct.
Anybody force you to plead guilty? Please that are accepted. I got 21 counts or 23 counts here. All right, Ms. Wilds, your name?
Elizabeth Wise, probation, Your Honor.
All right, I can't wait to hear why she hasn't been here for 2 years. Why hasn't she been here?
So, Your Honor, she has been in and out of multiple hospitals. The two main hospitals that she had been in was U of M and ProMedica down in Monroe.
When was she there?
All in 2023. There is some documentation also in the file. She'd also been this year.
Can you, wait a minute, slow down. Can you summarize what dates in 23 that she was hospitalized?
Years all of 2023 from, this is from UM. And then this one's all from
March 2023, November.
Hang on a second. March 2023 for how many days?
Doesn't say what. It just has
Okay, what else?
August 2023,
August, does it say what days?
August 18th, 2023.
Okay, what others?
September 30th, 2023, October 4th, 2023, October 2nd, 2023,
Did you just go to the hospital on those days? Wait a minute, let me finish my question.
I have,
Wait. Did you spend the night at the hospital on these?
yeah, most
When?
of the times, yes.
Well, I don't know what you mean. She's telling me March of 23 that you were in there, then August 18 of 23. Did you spend the night on August
Yeah,
18th?
all of them are just.
How long?
mostly overnight. Some of them are,
Slow down.
um,
Slow down. Do you have any records that tell me how long you were in on those days?
they're all records here from the hospital. I printed them all off.
This is where things start to unravel, and you can hear it in the judge's voice. Courts take medical emergencies seriously, but they require clarity, dates, durations, and proof of incapacity. What frustrates judges is vague documentation that shows hospital visits without establishing hospital stays. That distinction matters. A one-night admission might excuse a missed test. A same-day ER visit usually does not. And here, the timeline becomes muddled. Hospital visits before probation even started, overlapping years, and references to future dates that don't explain past absences. The judge isn't being cruel here. He's being analytical. He's trying to match medical events to probation obligations. And when those dots don't connect cleanly, credibility starts to erode. This is a key lesson in probation law. Documentation doesn't just need to exist, it needs to explain noncompliance at the exact moment it occurred.
Can you enlighten me, Ms.?
There's just a lot of that. She had something going on with her stomach and couldn't stop vomiting. So she was in and out.
When's the last time she was in? Huh?
2025.
Well, the last one you gave me was October 2 and October 4 of 23. And you also mentioned September 30 of 23.
Yeah, September 18th, I was in.
September 18th of what year?
2025.
When were you in the hospital after October 4th of 23, but before September 18 of 25? Who's this with you back here?
That's my grandmother. 33. She went in and then she's come out.
And that's probably just a one-day stay. And then,
Ma'am, first of all, your lawyer mentioned March of 23. You weren't even on probation yet.
this is
Let
what,
me finish. Then your lawyer mentioned August 18 of 23. You weren't on probation yet. I got September 30, October 4, and October 2 of 23, and then September 18 of 25. Are there any other dates?
and
October 22nd. Did I mention that?
What year?
2023. October 26th, 2023. October 29th, 2023. October 30th, 2023.
These were
September 2020.
That's not.
These were dates that she went in. I mean, do we have overnight stays? Any proof of overnight stays?
It's all I could get in time, because without, you have to pull medical records, it takes 30 days. And this is what I could get in time to come see you.
So it's just a list of days that she went to the.
Give the list of it. Doesn't really. And then this, I was in psych a few times too.
Bro. And Judge, if I may, the problem with the sober lady, unfortunately, because of the vomiting, she really couldn't blow.
Not all the time. That,
This is the turning point. When the judge uses the word absconded, that's not casual language, that's a legal conclusion. Absconding means the defendant didn't just miss appointments. She disappeared from supervision altogether. And in probation cases, absconding is one of the fastest ways to lose judicial goodwill. Notice how the tone shifts here. The court acknowledges addiction struggles, mental health challenges, even recovery efforts, but none of that explains silence. Judges expect communication. A call. A motion. Something. Instead, what the court hears is discouragement, fear, and avoidance. Human emotions? Absolutely. Legal justification? Not enough. This is where sympathy collides with responsibility. And it raises a powerful question for viewers. Should fear of consequences ever excuse total disengagement from the court system?
You just absconded for 2 years. Now you want me to...
sir, that's not the only reason. I didn't do what I was supposed to be doing. I got so disheartened with it. I kind of
Got so what?
like disheartened with it.
Disheartened? Is that what you're saying? I don't...
Stressed out, in a sense, I would believe, Your Honor. She just had a lot of medical, she had some substance abuse issues, heroin, she's off of that. She's doing Suboxone. She just had a lot coupled with her mental health and physical health.
Ms. Wilds, what do you have to say? Anything?
Yes, Your Honor. I don't know if you recall, obviously it's been some time. We actually dealt with all these issues, her medical, at her last violation hearing. You actually afforded her the opportunity to switch to a scram tether, to which she actually did not want to. So after court, she wanted to remain on her SoberLink issue. So the issue with her blowing into the device, she was given an opportunity to switch over to the scram tether. She actually chose not to do that. After choosing not to do that, we pretty much didn't hear from Miss Watts. I do have verification in my file that she went for a detox in October of 23, October 21, at Dawn Farm. After that, I've received nothing in regards to any type of update from that inpatient stay, if it was a 1 day, if there was any amount of time. But beyond that, there's no compliance on the file. She didn't do any of her court work program days. We rescheduled her after that last violation. No community service, no victims impact panel. Again, no indication of any further treatment. She stopped submitting to her chemical testing. She had provided proof of 12-step meetings up through August of, up through September 17 of 23. But again, nothing after that. She pretty much, after that violation, met with her briefly afterwards, and then she absconded.
So she has a letter. Well, the reason that she didn't want to switch is because of the expense. So she kept the sober. But she has a letter from Packard Health that she's been engaged in substance abuse, had a substance abuse disorder for more than a year, and she's consistently made her appointments.
What's the date on it?
This is November 25th, 2025.
I just don't know why you would have absconded, Ms. Watts. I have to be completely candid with you here. I don't understand why you would just stop showing up, not complying with the orders. Some of this is, I can rationalize in my brain.
I kind of just gave up because I was having such a hard time, and I was just kind of scared to come back.
So what am I supposed to do? Say that's okay? I mean, I'm trying to be understanding here, but I just can't. How much is owed in fines, Lisa? Can you tell me, please?
There's also a tax intercept.
Judge, I can give you that amount. It's $1,752.
So we filed a tax garnishment.
I don't want the job right now. I don't have a license. I live in the middle of nowhere.
She did bring some money with her today, Judge.
300 or something like that.
We did file a tax garn for 2025, Judge.
No, I understand. But we won't find out on that till...
This is the turning point. When the judge uses the word absconded, that's not casual language. That's a legal conclusion. Absconding means the defendant didn't just miss appointments. She disappeared from supervision altogether. And in probation cases, absconding is one of the fastest ways to lose judicial goodwill. Notice how the tone shifts here. The court acknowledges addiction struggles, mental health challenges, even recovery efforts. But none of that explains silence. Judges expect communication. A call. A motion. Something. Instead, what the court hears is discouragement, fear, and avoidance. Human emotions? Absolutely. Legal justification? Not enough. This is where sympathy collides with responsibility. And it raises a powerful question for viewers. Should fear of consequences ever excuse total disengagement from the court system?
February, right?
Right. And if she does pay or
Yeah, I know.
you waive any of that, I can stop it.
Judge, it may be unreasonable, but at this point, she also goes to a support group all week long, almost every day. It's for
You
all.
can go talk to your grandmother, whoever else that is, see if you can come up with $1,000. Or if you know that you can't, you can just tell me now.
Oh, I can't. She's not employed agent.
You put yourself in a horrible position here, young lady. You really did. So as far as I can tell, Ms. Wiles, she doesn't have any credit other than the one-day jail from the initial arrest. She didn't do a court work or community service, right?
That's correct, Your Honor. I only see the 1-day credit.
My grandma can vouch that I did do some community service I redid a door in a playground. I did that with my grandfather at a community service center in in London Township, Michigan.
Probation's revoked. You are to pay costs in the amount of $1,000. So I'm going to take this off for you. We're going to reduce that, Lisa, if, we'll know how it plays out here. You pay costs of $1,000, serve 93 days jail for 90, credit one for 92. If you pay costs of $1,000, I will suspend 65 of the 93, requiring you to only serve 28. So if you pay $1,000, you're in for 28. Otherwise, ma'am,
Okay.
you're going to be in for 92. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I wish you would have just come and talked to me 2 years ago.
This sentencing decision is layered and far more thoughtful than it may appear at first glance. Probation is revoked. Jail time is imposed. But the judge still leaves a door open. Pay $1,000, and the sentence drops from 92 days to 28. That's not mercy. It's consequence with incentive. And listen carefully to the judge's final remarks. This isn't anger. It's disappointment. The court is expressing what many judges feel when defendants disappear instead of asking for help. The system can't fix what it can't see. And once trust is broken, options narrow fast. This moment captures the harsh truth of probation law. The court can work with almost anything except silence.
Could have worked everything out. It was a big decision. I feel badly I have to do this, but you made good. Good luck. Thank you. Thanks,
Thank you,
Ms.
Judge.
Wiles.
Yeah.
Do I have that, do we have the file on Mr. Clovis? Is Ms. Alloway out there yet, Lisa?
This sentencing decision is layered and far more thoughtful than it may appear at first glance. Probation is revoked. Jail time is imposed. But the judge still leaves a door open. Pay $1,000, and the sentence drops from 92 days to 28. That's not mercy. It's consequence with incentive. And listen carefully to the judge's final remarks. This isn't anger. It's disappointment. The court is expressing what many judges feel when defendants disappear instead of asking for help. The system can't fix what it can't see. And once trust is broken, options narrow fast. This moment captures the harsh truth of probation law. The court can work with almost anything except silence.